you had a ruling, yeah, which somehow was misinterpreted in the circles. Yes. I understand, yeah, drunk driving is not a crime as long as the guy mwenye ameonja kitu ako in control of the vehicle. Tulikosea wapi?
Yeah, it is true. I made that that ruling,
yes.
And fortunately, it was upheld by the High Court. That wow. my interpretation and application of the law was within. I mean, was valid.
Yes.
Because under that provision of the Act, that Traffic Act, it is the offence is being drunk to the point that you are incapable of driving a motor vehicle. Not that you are too drunk. No, you are too drunk to the extent that you are incapable of driving or operating a motor vehicle. So it is not an issue of how much you have consumed. It is a question of, are you able to drive? Are you able to operate or not? So in that particular case, I was in Kiambu. This guy was arrested and brought before me.
Yes.
So the police officer came and gave evidence, and they were saying that this man, we were manning a roadblock. He came and we administered some alcohol on him. And if in the process of administering the alcohol to yes. test his level of alcohol in the body, he became unruly. He wrestled the base commander, Chief Inspector of Police, to the ground. The Chief Inspector of Police had to seek reinforcement from another officer who was there. But still, the two of them could not manage to arrest this person. Yes. They called a nearby AP officer who was manning a Family Bank ATM. Those the three of them now combined is when they be able to arrest this person.
Yes.
And therefore my question is, if this person is able to resist arrest and overpower two of you, is a civilian, is not trained, then are you trying to tell me that this person is incapable of driving a motor vehicle? It's the question, the answer is no. He might have been drunk, yes, I can see the alcohol report, but he was in a position to drive a motor vehicle.
Because if he can beat up three of you,
yes,
he's very well in good shape.
Exactly. And of course they were dissatisfied, and the DPP went to the High Court, and the judge, the High Court said that no, that's correct. If there's a problem, then go and amend the law. But this is actually the law.
Then, but I think
the problem is now the people who are celebrating were those who are in that. Some were even telling me that they were working with my judgment. They scanned and they were working with the judgment. When the police were arresting them because of being drunk, they could just show them the ruling from
it is not how much I have drunk.
Yes, I'm able to control the machine. Yes.
I think, Basi, instead of the alcohol,
yes.
we should have a unit of police officers that if you can fight this number of police officers,
yes.
then
you're given a medal.
Yeah. Or you're off the hook.
No. We don't want to encourage people to fight police officers.
Yes.
But sometimes when you're interpreting the law, it's good to stick to
yes.
the letter and the terms of the letter and the terms of the law.
Okay.
Yes.
And sir, are you a Christian?
Yes.
You believe in God?
Real time. I'm a Christian by practice,
yes.
by birth, and in everything that I do.
Thank you.
My church is Deliverance Church, Kimberley.
Thank you,
yes.
Which is very good. And you read the Bible?
Of course I do.
You must have come across one of the commandments that talks about do not judge others.
Yes.
Where does the separation comes between what the Bible says
yes.
and the career path you choose?
The commandments are about don't pass judgment to someone when you don't know that case. Don't pass judgment because you don't understand, you don't appreciate the reasons why that person did whatever he did. Judgment belongs to God.
Yes.
Now that one is separate. Here we are in this world. Someone has committed an offense, he has to face the law, listen to the evidence, and pass judgment.
Yes.
So it's perfectly in order. I mean, it's not against what the Bible says.
Yes.
Yes, this is separate.
And
because you remember the commandments, when the commandments were coming out, is where there was the era of collective responsibility.
Yes.
You remember that era when one individual commits an offense in Sodom and Gomorrah.
Yes.
The whole society it's wiped out.
Yes.
So now we are in the era of individual responsibility. Now this criminal is individual criminal responsibility where you have to end up in court, and we must judge.
Okay.
In accordance with the law of man.
Okay.
Yes.
Up to that point, we are together.
Yes.
And then we come to the process of issuing a judgment.
Yes.
As first of all, I'll go to the law process. As a judge, you're supposed to, Professor PLO Lumumba was on the show,
Yes.
and he mentioned that the judgment is based on evidence produced, right?
Yes.
So as a judge, you can sit there and see that a person could be innocent.
Yes.
In fact, personally, you are convinced that they are innocent.
Yes.
But according to the law, they have not been able to prove their case.
Yes.
So they will be punished according to the law.
That's not correct.
How so?
When you have been taken to court with an offense,
Yes.
it is not you to give evidence that you have not committed the offense.
Yes.
It is the people who have taken you to court. It is the prosecution that have got the burden of proof that
Yes.
you stole someone's cattle
Yes.
or a goat or whatever it is.
Yes.
And this is the evidence. So and so found you selling this animal at the market. And this animal is the one that actually belongs to this person who had made a report that it was stolen. And even if you go to court, and that's why we say you have got 3 ways of defending yourself.
Yes.
When the court has found you to have a case to answer, the judge or the magistrate will tell you that we have seen the evidence of the prosecution and we are satisfied that at least on the minimum there is an offense, there is some evidence that requires you now to defend yourself, but you have 3 options. You may keep quiet and wait for the decision of the court,
Okay.
or you give evidence on oath, or give evidence not on oath. So the point is, the burden is not on you as the accused person
Yes.
to disapprove the case.
Okay.
The burden is on the prosecution to table concrete evidence against you. But when you are, the role of the judge or the magistrate is to convict the guilt and acquit the innocent.
Okay.
And a good judge and a good magistrate or judicial officer in general,
Yes.
the principle, the rule of the thumb is that we rather acquit 99 guilty people than convict one who is innocent.
But we still have cases of people who end up in jail and they are innocent. We have cases of people who've been released to the extreme of 40 years,
Yes.
having served 40 years,
Yes.
and they were innocent. So is this now, does this now fall on the judge who actually gave the judgment, who passed the judgment, or the prosecution that really went in on that person?
You see, you cannot make that kind of conclusion.
Yes.
That someone has been in jail and another court that had acquitted that person.
Okay.
Because the innocence, who determines the innocence? The court that convicted made a finding that you're not innocent, right?
Yes.
So at that point, you're not innocent. There is another court that has overturned this decision
Yes.
and found this person to be innocent, to have been wrongly convicted. Or there could be other reasons why someone has been acquitted. Could be on a
Yes.
technicality.
Okay.
The charge sheet was not properly drawn, but the person, the court that convicted was convinced that this person was guilty. So it's a process, and that's why we have the system of courts. It's a matter of application and interpretation of the law.
Okay.
And that's why we got the hierarchy of courts, from the magistrate court to the high court to the court of appeal to the Supreme Court. It's simply because it means that a judge or a magistrate seated separately somewhere are capable of reaching different verdicts. Okay?
Okay.
So I can't convict you today as a magistrate. You go to the High Court, and the High Court overturns my decision and finds, no, this person was wrongly convicted. This person is actually innocent. The DPP goes to the Court of Appeal. The Court of Appeal says the judge who overturned the magistrate's decision was wrong. The magistrate was right. This person is not innocent. Go back to jail. The person can go to the Supreme Court. The Supreme Court may agree with the judge of the High Court, or disagree with the judge of the Court of Appeal, or agree with the magistrate. It's all about interpretation and application of the law.
Which means...
Unless someone, but it's very rarely that you just come up and say, because of my own personal biases, I want to convict you. I don't think there's
Okay.
such a judicial officer that exists in the judiciary.
Which means,
Yes.
then, from what you've said,
Yes.
the fate of an accused could depend on the interpretation of whoever is passing the judgment, his or her interpretation of the law.
Yes.
So if I was to be brought before a certain judge,
Yes.
right, who has a certain interpretation,
Yes.
they would say I'm innocent, whereas another judge, for the same case, they would say I'm guilty.
Yes.
So ni pata potea.
See, Pata Potter, you see what happens that, you know, the what we call open and shut cases.
Yes, yes, yes.
I mean, if you have assaulted someone,
Yes.
you take it to court, the person you assaulted have come to give evidence.
Yes.
The doctor who treated you comes to give evidence and produces a P3 form.
Yes.
That's an open and shut case. I mean, there's evidence. I mean, there's not a question of interpretation anymore. This is now 2-3 people have come to give evidence. Such a case, even if you go where the interpretation is the same because this is a straightforward matter. But there are those cases that actually needs, when you look at the material that have been brought before court, it's a question of marrying this material, this evidence, and the facts that are presented. And you may apply differently from one judge to another. That one is given. But it's not, we can't say that it's actually an issue of pata potea.
Okay, sawa sawa.
Yes.
When you talk of technicality, a friend of mine shared a story with us about an incident that happened in Siaya. Someone was speared to death in a local center, and people saw.
Yes.
But then when he was taken to court, he was released because no one was willing to come and testify against him.
Yes.
I believe that was being released on a technicality, right?
No.
No, that's lack of...
There's no evidence. There's no technicality.
There's no evidence.
Yes.
So if as
The
a
people
judge...
People are supposed to give evidence, not turned up.
Ah, okay.
Yes.
So if as a judge you are part of the people who saw that happening,
Yes.
still you'll release that guy.
Yeah, we know we are in an adversarial system. Even if I'm a judge and I've seen an offense being committed, and the person is brought before me, I want people to come and give evidence. In fact, I should not even hear that case. I need to recuse myself because of conflict, because I saw. But generally, the fact that the offense was committed and I saw does not mean that, okay, this person just brought to court and say, okay, oh, see, I even saw you. Okay, then they just go to committee. There's no need of calling more evidence. I saw you committed this. I will still sit on my seat, ask the DPP, the prosecutor, bring evidence. Who saw? Okay, this person saw. Okay, what happened? Did he die? What? As if I'm not there. That's the system of law that we are in.
So you have to sit there and pretend that you know nothing about what is going on.
But
so if you saw, and the evidence is not strong enough to convict him, then you'll still release him despite you seeing them.
Yes, and you know, those are what the principles of what we call the Bangalore principles of judicial independence, which one of the principles that we must be impartial, isn't it? So if you are not impartial, then it means that you are going into the arena of the case and say that I am part of the people who saw this offense be committed. That ought not to be the case. I want to say that actually the best thing to do is that you need to step aside from that case, recuse yourself and say, I can actually be a witness in this matter. So this should not be brought to me. Or the prosecution will not bring that matter before you are caught, if they are aware that you saw it. Because your mind is already biased. And you see the oath of office that you determine and dispense justice without fear, favor, or bias.
Thank you.
So once your mind is biased, then you lose it.
And for the years that you practiced, for the years that you've practiced as a magistrate, to the level of a principal magistrate, you've sent a few people behind bars.
Many.
So what kind of security do you need, Ama, for the long time, as in your safety depends on how long someone stays inside. If you send someone in for 10 years and you're still around the time, you're still safe. You can walk around, you can... How difficult is it to live a life where you feel like you could be hunted by anyone for a vendetta? Someone has a vendetta on you for something that probably you made a ruling on very many years ago.
Yes. No, it is true. What normally happens is that we try to get the judiciary to ensure that judicial officers don't overstay in one station or in one region for quite long,
Okay.
because we are human. You may have actually sent someone to jail. You are convinced that this person committed the offense, and yet the person was innocent. So there's that bitterness that comes when he comes out with it. So it's
Yes.
possible, because we are human beings. Someone can get you attacked, not necessarily himself directly. And we have those things have been there. We have seen those. It was in Akuru, where the accused person attempted to stab
harm
a
a judge.
magistrate. Then there was another one in Eldoret, where some accused person, through other people, they arranged to go and kidnap a child of a magistrate. So those scenarios are there, and we are alive to that. But now we go back to the oath that you dispense justice without what?
Yeah.
Without fear.
Yes.
So we just assume that people will be reasonable enough and know that this is a process of nothing personal. I worked in Kibera, which is a purely criminal station. Yeah.
Criminal cases.
Only. They don't hear those cases of Mashamba. In Kibera, it is just criminal. And you can see the court is inside the slums. And you stay in that court. From open court, you go to the chambers, write rulings, and at 6, 7, you jump in your car and you drive away. And when I was Secretary General of the Judges and Magistrates Association, KMJ,
Yes.
one of the things we're pushing is to enhance security, provide security for the magistrates.
Yes.
Judges are given police protection around the clock. Yeah, magistrates are not. And you see, the magistrates are the ones who handle the huge chunk of these cases.
Yes.
So people who are vulnerable are the magistrates. They're the one who sends people to jail on an hourly basis, if you ask me, across the country.
Yes.
So security threats and security for judges is a valid concern that the government need to look at.
And it must be a system that really messes up with your feelings at some point, because, like you said, you're human, right?
Yes.
And I read somewhere that one time you released someone.
Yes.
You ordered for their release despite their pleadings.
Yes.
That they probably wanted to remain inside.
Yes.
And then they were later killed.
Yes.
When you have incidents such as those, do they influence your future rulings and judgments, or every case is independent?
No, much as every case is independent, but when you have those kind of experiences where there's extrajudicial killing, immediately someone has been acquitted, what came in my mind that I ought to have listened to this person, because I could not understand why someone who has been in custody for more than 2 years with an offense of robbery with violence, today he has got a lifeline where the prosecution now want to drop the case, withdraw the case, and get him go scot-free. And the guy is resisting. Say, I don't want to be released under that section of the law. It's called Section 87A of the Criminal Procedure Code, whereby you can be released now and arrested the next second.
Congestion of freedom.
So, we were a congestion of freedom.
Yes.
So for me, I found it absurd that, what's wrong with this guy? So the guy knew that these people are going to finish me. So now going forward from there, of course, it was a bad experience. Now I will give him detailed attention to what the accused persons, and I explain to them what the prosecution is saying and what is their response, and I record, and I try to go out of my way. Do you really understand what it means? Do you know why? Do you know exactly what it means by being released under that section? Mm-hmm. So if there's a resistance, then I will also agree with them that no, they have got valid reasons. If you want to drop the case, they just say that you've got no evidence against them.
Yes.
So that we release him
unconditionally.
Yes, unconditionally.
And do you have you, in the years of your practice, have you had scary moments in court? Like people you look at and wonder how the society survives with them around?
Yeah, there's those moments, some are scary, others are not that scary. It also depends on where the station have been working with.
Yes.
The only moment I found myself, and I'm like, what's happening? There was a gentleman who was brought to court, and I saw the charge sheet, it's called Jesus. So I was like, so I became curious. Then I called this name out when I saw the charge sheet. Jesus? So the man stood up and said, yes, the Son of God himself. So I quickly knew this one is a Mathare case.
Uh-huh. So that was his name.
You see, he was arrested and was asked to produce his ID.
Aye.
He didn't have the ID, so he told the police, "What's your name?" "I'm Jesus." So the police had got nothing else to write because the judge it must have some name,
Yes.
isn't it? So it must have. That's why we have got also known as AKA and what have you. But they must have some name. We don't take unknown people
Yes.
to court. So the guy told, "Okay, but
I'm Jesus.
yes."
So did you release Jesus?
I ordered Jesus to be taken to Mathare to undergo a psychiatric assessment and find out actually where's the problem.
And when it comes to the
This
court,
guy had actually tried, he had attempted to jump over the fence of State House. He was arrested by those elite.
but he was Jesus. You could have allowed him.
The police didn't know. They wrote that he was a robber. But you see, even the Bible says that Jesus will come as a thief, isn't it?
The police did not know Jesus.
You know?
And when it comes to the judiciary and matters of the Bible, you mentioned something very interesting.
Yes.
When I asked about, you told me that judicial officers are not supposed to talk to the media, you're not supposed to respond to personal attacks. And then I asked whether, by the way, does that mean we have judges on social media, they have accounts, but they are limited as to the kind of interactions they make?
Yes, as I said, that the judiciary, life of judicial officers is a bit restricted.
Yes.
For a number of reasons. Yeah, so first of all, even if you are attacked on the social media or the mainstream media,
Yes.
a judicial officer doesn't have the opportunity to come and counter. So all the lies and everything that is put there,
Yes.
you just, we have no opportunity to go and put the correct perspective of the things as they are supposed to be.
Yes.
You cannot call a press conference and say, okay, what you people are saying that this has happened, this is not correct. So you leave it to the court of the public opinion to pass judgment, but you know what you did is within the law. We used to have a judiciary spokesperson.
Yes.
Many years ago, by the name of Dollar Indidis.
Yes, Dollar Indidis.
That would be before I joined the judiciary, but I read somewhere when I joined judiciary that he actually sued is it Pilate or for killing Jesus Christ. And I think the state of Israel was the respondent. And that ended his exit from the judiciary. Then after the new constitution, we had the director of public, the director of judiciary, public communications.
Yes.
But it's a department, director does not come actually for individual cases of judges and magistrates to address the media and correct things are supposed to be.
Yes.
So you are just there as a judicial officer with your life that is restricted, just like that. But we have judges like me. I've always been on the social media.
Yes.
But the problem is, there's a time that I posted something on the on Facebook.
Yes.
Then someone came who is an accused person before me and commented and said that can we have lunch?
Oh, really?
Honorable Khaemba.
Yes.
On the commentaries. So I said, like, so I pulled myself away from
you had to?
For quite some time. Because now, how was I supposed to respond that comment?
That's
being
a
invited
tricky one.
and in public.
That's a tricky one.
Yes.
So if I can take you back, Kidogo, a former spokesman of the judiciary matters, Dollar Indidis, was categorical, as in was specifically fired for suing Pilate for killing Jesus Christ. That was why he was released.
Fine, I wouldn't want to say that, but I understand that could be part of the reasons. Because I cannot say that I saw the letter exiting him from the judiciary.
Yes.
But that is what we found, the talk in the judiciary.
Okay.
That our colleague has left because of this. Yeah.
And people have some of the most weird cases that they bring before a judge. Come on, that should be one of the most bizarre cases.
Yes.
Are there cases that you see and wonder why they are before a court, but you still have to go through and listen to them?
Yeah, they are. Kenyans have become so litigious that I think the new constitution has opened up that space.
Yes.
For litigation.
Yes.
So a small offense something which can be resolved ends up on the doorstep of the court.
Yes.
For me, this is what sometimes I could pay people just to get them to negotiate. Because I will ask, someone has brought a case of theft of farm produce.
Yes.
And what is it? There are 5 avocados.
5 avocados?
Yes.
They brought someone to court for avocado?
Yes, for an offense of stealing farm produce. So I asked the complainant, how much is this? He said it's 150 shillings.
Yes.
Yeah, because now we have got many cases there.
Yes.
This is a case which you can resolve. If the complainant pays you 150,000, the accused person, will you withdraw that case?
Yes.
He says, I have no problem if he pays me that much.
Yes.
Okay? Complainant, accused person, do you have 150 shillings? Say, I don't have. I want to pay for it.
Yes, yes, yes.
Then I pay and we drop the case and just like that.
And it's done.
Is that, yeah, but because now we have got cases where people have lost millions for the bank, theft, robbery, the process of robbery, someone died, or what have you. Are we going to an avocado turn up? And he has got 5 witnesses to come and testify. By the time they testify,
each avocado has its own witness.
Yes. By the time you are done with the case, avocados will have got bad. Isn't it? They will be spoiled.
Yes.
So what are we doing? And that's why we've been encouraging people to embrace the alternative dispute resolution.
Okay.
So mambo ingine, go to the elders, village elders, go to the church leaders. Okay. They bring people together and help so that we only the most serious cases ends up in court.
Okay. 2 things before I let you go.
Yes.
One is my curiosity that actually inspired my walk, my journey to look for a judicial officer on the show.
Yes.
I was interested in a line, witness interference.
Yes.
And witness interference was a case where a witness had been killed. So the case cannot proceed because of witness interference. The same goes to very many cases there. But also I understand that witness interference is probably bribing a witness or letting them or allow, talking to someone nicely that they withdraw a case. That's why they have institutions of witness protection, I believe.
Yes.
But then for me, when it comes to the language of the court,
yes,
right?
Yes.
I don't feel like it's heavy enough.
Yes.
Because putting witness interference, killing someone under that umbrella, and then bribing someone under that umbrella. So you mentioned that there is an explanation behind that.
Yes.
But are there cases where it's just witness interference and then the case just disappears without the weight of the term witness interference being delved into?
You know, when the court is imposing terms of bond,
yes,
it explains to the accused person or accused persons what ought not to do under witness interference. Because witness interference is a very serious issue that if it is proven, even if you are out on bond, the bond can be cancelled by the court and remain in custody until the case is completed.
Yes.
So the court always gives the conditions on bond. And under witness interference, they will tell you, don't contact any of the witnesses, either directly or indirectly. Don't send someone to go and talk to them. Don't call them. Don't SMS them. Okay? The court cannot say, don't kill them. Because you see now that one's a separate offense. If you want to go and kill someone, it is murder. Now it is not about witness interference anymore.
Yes.
You will be arrested and charged with a different offense away from now this particular one.
Yes.
Okay? So to me that there's nothing wrong because the court has, having explained to you, don't do a number of things. Then you go to the worst and kill the witnesses so that the case is killed.
Okay.
Yeah, now that one becomes a separate matter that to be charged with.
And the weight of the punishment someone gets upon judgment is on the judge's discretion. Let's say, for example, the maximum sentence for a crime is 10 years, right?
Yes.
So it's up to the judge to decide whether you'll serve the 10 years or they will give you 5 or 2 years. So in that case, what influences a judge's decision in that regard?
There are 2 things. We have got cases where the sentences are based on the discretion of the judge or the magistrate.
Okay.
But there are cases where there's no discretion. Once you've been found guilty, you'll be sentenced that one sentence. You get the point?
Yes, yes, yes.
So there are offenses where the law has said, if convicted, he shall. So the moment you see shall,
Yes.
then there's no latitude, there's no discretion.
Yes, yes,
He
yes.
shall be sentenced to 10 years imprisonment. So once you are convicted, that is it. There are cases where the law says that if the accused person is convicted, he is liable to, meaning that that's a maximum.
Yes,
Now
yes,
that's maximum, if it's maximum 20,
Yes.
you are liable to 20, you can be jailed for 2 hours.
Okay.
Or for 20 years. What matters is your level of how you mitigate the offense. The court looks at a number of things. The mitigation that you offer, someone can come and say, okay, I know I've been found guilty, I'm an orphan, or someone came to court and I convicted him, and the mitigation said, you know, my mother and my father passed away. Then there's a lady who stood up and said, what? I am your mother. You want to kill me? I think I was in Kigumo.
Yes.
You want to kill me, and I'm dead.
Ouch!
So they said, okay, so you are lying even at your mother. So the court looks at the number of years or the period that someone has been in custody.
Yes.
Someone has been in custody for 5 years.
Yes.
Okay? The maximum sentence is 5 years, for example.
Yes.
Why would you send this person for another 5 years? So cumulatively, he will
Yes.
be in jail for 10 years.
Yes.
Because he was in a remand for 5 years. Now
Yes.
he's going to prison for 5 years. So the court looked at, okay, I've looked at the number of years, the period of in custody. You ought to be, you're liable to be sentenced for this, but I'm going to sentence you for 6 months. And see rather the age of the accused person. You look at someone.
Oh,
who
the
is
age
so-
also?
Yes, also a factor. The court look at how old are you.
So
I'm
the
75.
grandmother from Embu, the gangster at 80 years, akikuja, you just give them 2.
I'm not saying that you just must give them 2, but I'm just giving the number of factors that the court looks at.
Ah.
But the court doesn't look at how handsome or how beautiful you look.
For real?
Yes, no.
Wow. Because looks can
But
be
I think
deceiving.
you saw the Miss what? Miss Langata.
Yes, I remember.
She was Miss Langata, but she was convicted, right? And
Yes,
sentenced.
yes, yes. People really make reference to that too.
Yes.
And the final thing, when releasing judgment,
Yes.
the chance that the accused gets,
Yes.
wejitete, will that count in the final judgment? It's like you came with the written judgment, but based on what they say, for example, the guy who talked about being an orphan,
Yes.
there's an allowance to which they can move you to the extent that they were to get 20 years, but you're like, let me give you 5.
So you delete.
Yes.
No. You see, the judgment ends at conviction. When you come to court, the judgment is written, typed, printed. It ends to the point, at the point of, I have now looked at everything, I've looked at this, I've analyzed this, I've looked at your defense and your evidence and your witnesses, and I am convinced
Yes.
that you are guilty as charged, and therefore convict you. That's
So
the
this
end.
one comes
that
before.
will be the end of the typed judgment. Okay?
Na ile mnaulizana
Now,
mtu?
that's conviction. If there's conviction, then there's sentence. Now, having convicted
yes.
you, okay?
Yes.
Now, I offer you a chance to mitigate.
Okay.
You understand?
Yes.
Now, that's when you see now, the judge is right and
Writing.
writing.
Yes.
Now, just after the conviction, in addition to now the typed judgment.
Yes.
Then after the mitigation, you ask the prosecutor if the prosecutor has got previous records
Yes.
of criminal liability or criminal convictions on the accused person. You also record. Then now you give sentence. So that will be the notes after. The proceedings
okay.
after the conviction.
Yes,
now
yes,
that's
yes.
done now in Apple, the open court.
Yeah.
Now you finalize.
So,
Then when now you can go and rewrite and retype. Now
so
to
whatever
bring-
someone says, when they are given a chance to defend themselves, the final, like,
Yes.
if you have you anything else to say,
Yes.
could count. It could help in the final.
Yes, they, in most cases they do. Because in mitigation,
Yes.
someone may say that I am pregnant in mitigation.
Yes.
And the law is you cannot jail a woman who is pregnant. You cannot sentence that person to death. You understand? So now you revert to life imprisonment. And all this time, you didn't know that the person was pregnant, right? So mitigation offers a chance for the court to appreciate the the
Yani-
status of the accused person.